Sir, we are able. We are able.
You are able to see the slides or some other thing?
No, sir. Able to see slides, sir.
You are able to see the slides, right? Okay.
Yes. Sir, we request you for presentation mode, sir.
Yeah.
Sir, please.
So can you see the presentation mode now?
Yes, sir. Yes, sir. We can.
Okay. So good afternoon, everyone. Thanks for the kind introduction, and thanks for the coordinators of AICTE sponsored International Symposium on Drug Discovery in the next decade for giving me this speaking opportunity. So myself, Dr. Yoganjanelu Kassetti, I'm working as a patent attorney for K&S Partners. So the topic of my presentation is about types of patent applications and overview of patenting procedure in India. Before actually jumping into the topic, I'll explain certain basic concepts about the patents, and then we can discuss about the actual topic, that is about the patent applications and overview of the patenting procedures. So let us first understand what are intellectual property rights. So innovation promotes the creation of new works in the areas of technology. So what does this mean? So we need to understand what is first intellectual property rights. So what is intellect actually? So as you know, innovation promotes creation of new works in the areas of technology. So to simplify this, I would like to take the example of our network technology evolution. For instance, if we see long back, we were using a 2G technology for internet related stuff in our mobile phones. But after some point of time, we used 3G technology. Currently, majority of the people are using, of course, 4G technology. And now we are seeing that some of the mobiles have already launched 5G technology also. So there is a constant evolution in the technology, which is happening because of the efforts of the engineers in this particular area. So because of their innovative efforts, we are enjoying the technology benefits. So technically, they should be rewarded for their innovative works, right? So intellectual property rights provides protection for their innovations in the form of patents, trademarks, design, indications, plant varieties, copyrights, etc. Okay, let's first understand topics about patents. So we'll look in detail about the patents. So patent is an award for the inventor and a reward for the investor. So how does it gives award for the inventor and reward for the investor? Let us see more details about. So once a patent gets granted, an inventor or the applicant of that innovation who filed for a patent application will get a 20-year monopoly in that particular country, and that monopoly will be given by the patent office of that particular country in the form of a patent. So once an invention is granted as a patent, then 20 years of that tenure of active patent, no other person can work on that patent without obtaining permission from the patentee. Patentee means a person who has obtained the grant of patent from that country. Okay. So why this 20 years monopoly is required? So if you see, into the commercial aspects, why a person innovates something? Because he wanted to give a betterment to the society in the form of his hard efforts, whatever that he had put, and that he has to bring out that technology evaluation to the society. And if with his hard efforts, if he is putting that energy, efforts to get the new product into the market, and if somebody copies it and gets the similar product in the market, then whatever the hard effort to ideate and innovate that he has put will go waste, because the other person is just merely copying and selling it at a much lesser price. So because of these issues, this patent gives a protection for the innovator, so that 20 years only he can enjoy the monopoly, and no other person can copy it and commercialize it. So in that way, the innovator will be rewarded. So this is actually for a specific period of time. So after 20 years, patent will get expired. Then anybody can work on that innovation. Okay. So moving on to the next slide. So patent is territorial in nature. So what does it mean? So, you know, in the world we have like several countries, but if we need patent protection in India, need to file patent application to the Indian Patent Office. If you need innovation to be protected in US, you have to apply for patent in to USPTO, US Patent Office. So it is a territorial in nature. So wherever our patent needs to be, our innovation needs to be protected in that particular country, we need to apply for the patent. Okay. So there are certain requirements which an invention need to fulfill to get an eligibility as a patent. So an invention will be granted in the form of a patent if it satisfies the below. Hello, can you hear me?
Yes, sir. Sir, we can hear you, but your presentation is not visible, sir. We can't find your
My
slides.
presentation is not visible.
Not visible, sir.
Oh,
No.
one
No.
moment. I just now you can see.
Not it, sir.
One moment. I'll try to reshare my slides. Can you see now?
Still at sharing, sir. In sharing mode.
Okay.
Yes, sir. Now we can see.
Yeah. So as I was mentioning about the requirements of patentability earlier, like an invention will be granted in the form of a patent if it satisfies the criteria such as novelty, non-obviousness, utility. So novelty means it has to be completely new, which should not be known earlier at all. So that gives the criteria which needs to be fulfilled for novelty. So the second one is non-obviousness. Non-obviousness means it has to have inventive step. We'll see details about it in the later slides. So utility means it should have some kind of industrial application. If you are identifying something, it should have utility industrial application, without which there is no meaning to identify something, right? So these are the certain criteria which are essential for patentability, and this is common for most of the geographies. But when it comes to the subject matter eligibility, this is slightly country specific. For example, in India, new form of known drug, for example, crystalline forms, these are as such not patentable unless they meet certain criteria. So also enablement, working examples, these are certain essential requirements. So let's see more about novelty. So if you look at the compound 1, this is already known in the prior art, whereas the compound 2, now we need to identify whether it is not novel or not. So if you see structurally, both the compounds are almost similar, like it has pyridine ring, both have pyridine rings, both have phenyl rings, and both have dimethyl amino ethyl ring system. But only the difference what you can see is the chlorine group. So because of this presence of chlorine, the compound 2 is novel over the compound 1. So this will help us to identify novelty, like what distinguishing features are present between the prior art as well as the current invention. That we need to see, and accordingly we can get to know like whether our compound is novel or not. So next, move on to the next step. So in inventive step, what criteria we will look into is technical advancement or economic significance. So let us take the same example. If you see compound 1, this is useful for treating breast adenocarcinoma. When this compound was administered to a patient, there was a reduction in tumor growth up to 30 to 40%. Okay, and now the present invention is what we are looking at. It is a compound 2. This compound 2 has only the difference of chlorine being an extra moiety. So now when this compound 2 was administered, it has reduced the tumor growth size in a patient from 60 to 70%. So because of that improved activity, the technical advancement is seen with the compound 2 over the compound 1, and hence it will be acknowledged for its inventive step. So this is how we need to see novelty and inventive step. Of course, if you see industrial application here for this compound, the industrial application is treating the cancer related cells. Okay. So now actually we'll get into the topic, because I felt a little background is essential before jumping into the actual topic of patent applications, so that there will be a continuation. Okay, let's see about the types of patent applications. Okay, so how this patent will be granted, and what are the various means of applying this patent, and what are the forms in which we can apply for a patent. So that we will try to understand from in the few slides from here onwards. So there are multiple types and various ways to file a patent application. So ordinary application, in the ordinary application, there are two types. One is provisional application. The other one is complete application. So when a provisional application will be filed, that we will understand first. So if the invention is conceptualized and you have preliminary set of results, then you can go for filing a provisional application. So after filing a provisional application, you will get 12 months of time to file a complete application, during which the span of 12 months, the inventor need to carry out the full experimentation associated with that particular invention, to show that invention full-fledgedly works at a greater level also. So in that way, the concept of provisional application will be useful to block the priority rights. However, sorry, if the invention is completely conceptualized and there is no further data is required, and you have all the biological activity data, everything, then directly you can go for complete application filing rather than provisional application filing. So now convention applications. So convention applications. So as I mentioned in my earlier slides, patent filing is jurisdiction, patent protection and patent filing is jurisdiction specific. Okay, so if you want to, if you apply for a patent in India, you will get patent protection from Indian Patent Office, and it is only applicable for India, but not for US. So in that way, every innovator has to file application across the globe wherever he wants to file his patent protection. So within 12 months of the filing of a provisional application, an inventor can file application across the convention application countries. There are 192 members in Paris Convention thing. So where 192 member countries are covered in through Paris Convention. So in all those countries, from the date of priority of filing the application, a complete application can be filed in all these countries to protect his innovation in the form of a patent. And there is another route where PCT application will be filed, that also can be filed within 12 months from the date of filing of a provisional application or a priority application. So in the PCT application, there are 155 countries. So the idea of filing PCT application is it gives almost 30 to 31 months time for filing an application through national phase in other countries. So during that time, the applicant can assess the commercial value of the patent in each and every country, and wherever he finds that there is a potential value for his innovation, in those countries he can go for a filing a application, because there is no meaning in filing application in all the countries, in 155 countries or 192 countries, because patent filing is an expensive process. He has to be selective while choosing the countries. Wherever his invention is having potential scope for commercialization, there only he can file the patent application. So accordingly, this PCT route will provide additional time for the applicant to identify the countries wherever he can file his application. So apart from this, there is something called patent of addition. So if there is anything improved or modified on a patent, then that will be filed in the form of a patent of addition. So here novelty will be seen over the main application. So anytime during the life of the patent application, this patent of addition can be filed. So a parent needs to be granted before a patent of addition can be granted. So in case of patent of addition, separate request for examination is need to be filed. So it has a lifespan similar to that of the parent application, but there is no need to pay the maintenance fee. So even an independent application can also be converted into a patent of additions. If parent application is revoked, patent of addition may be converted into independent application. So if there is a minor improvement, then those kind of things will be filed as a patent of addition. So next we will see about the divisional application. So suo motu by the applicant are triggered by the unity objection, this divisional application filed. So under what criteria divisional application will be filed? Let us try to understand. So for example, we can file only one invention in one patent application. We cannot file multiple inventions in one single application. If we file multiple inventions in one single application, then there will be an objection raised by the Indian Patent Office saying that this particular application contains multiple inventions. So only one invention will be allowed. Please choose that invention and let us file application. And you can file divisional application for the remaining inventions. So that is the kind of objection we get from the patent office if we include multiple inventions in a single applications. So in those cases, that additional inventions can be filed as a divisional application. So these divisional applications can be filed at any time during the pendency of the first applications. So no new subject matter can be added at a later point of time once the application is filed. Claims to be directed to the separate invention. So here also separate request for examination is required. So life term is similar to that of the first application. Separate maintenance fees needs to be paid. So there is additional aspect, something called a foreign file licensing. So if at all, if for some reasons, if the innovator does not want to file an application in India and he wants to file application only in US or in other foreign countries, then but still he has to inform the Indian Patent Office that he would like to file his application outside the India and he does not want to file India. So in that scenarios, foreign file licensing is one route where applicant can request the government of India, so saying that I wanted to file my application outside India. So when he makes such application within 6 weeks from the date of filing of such application for foreign file licensing, Indian government will give approval to go ahead. And however, if it finds that there is some issues associated with that application, especially with respect to the defense aspects related to it, then under secrecy direction, they will not allow such applications to file outside the India. So post dating of application, this is very interesting concept. So suppose, let's say, as I mentioned in my previous slide, within 1 year from the date of filing of provisional application, we need to file a complete application. However, for some reasons, if the inventor could not file complete applications within 12 months, he can post date the application. Because of this post dating, he can get additional amount of time so that he can file complete application at a later point of time, so that he can conclude all his biological activity studies or the studies which are pending for his application. Okay, let us see the patenting process through its phases. So there are primarily 4 steps. We can see individually all these steps. So one is filing. So before filing of any patent application, it is always advisable to go for prior art search to understand whether the invention is patentable or not. So after identifying that the invention is patentable, then you can better go for filing, and then it will be subject to the next stage called prosecution. And this is called examination stage. Prosecution is nothing but examination stage. And then it will enter into the grant procedure, and after the grant it has to be renewed yearly, or there need to be annuity maintenance criteria which needs to be fulfilled by the applicant. Okay, let us see this process step by step now. So we have to file the application with the patent office of your invention, and then within 18 months of that filing of that provisional or complete application, it will 18 months after the filing of the complete application, it will be published. So that will be open for grant of opposition. So meanwhile, a request for examination can be filed, and there will be examination happening at the patent office for the application, patent application, and they'll issue a first examination report. After issuing the first examination report, applicant has to file a response to that first examination report. If the objections are, if whatever the objections raised by the patent office are satisfied with our response, then patent office will grant the application as a patent. If still the examiner has any further reservations, he will issue a hearing notice. So during that time, we have to attend a physical hearing, or even through video conference also we can attend the hearing. So after the hearing, we need to file post-hearing submissions within 15 days from the date of hearing, and then the patent will be granted. So after the grant of patent, there is something called post-grant opposition period. So after 1 year from the date of grant of the application, it will be open for a post-grant opposition. So then there will be, if anybody wants to oppose that patent, yeah, it can be done in the form of post-grant opposition. Otherwise, if after the grant also, if somebody wanted to, oppose the grant of that opposition, patent, then they can go for the revocation of patent. So once the patent gets granted, then there is a need to, make annual payment for the renewal of the patent maintenance by the Indian patents. So we have 4 Indian patent offices across India. One is in Kolkata, the second one is Mumbai, Delhi, and Chennai. So how to choose the patent office while filing this patent application? So it depends upon where the applicant normally resides, or his domicile, or a place of business, or the place from where the invention actually originated. So these criteria will let the applicant decide through which patent office he has to file the patent application. If the applicant has no place of business or domicile in India, then it's the address for service. So which means that patent agent's address will be considered as the address for service. Accordingly, the patent can be filed to that patent office. So let's see a few examples. For example, Mumbai patent office jurisdiction will be like for the state of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, and Union Territories of Daman and Diu and Dadra Nagar Haveli. All these applicants, they can file application in Mumbai. Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and Union Territories of Pondicherry, Lakshadweep, and Telangana, they can file patent applications to Chennai patent office. Similarly, states of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, Delhi, and Union Territory of Chandigarh, they can file patent application to New Delhi, whereas the rest of India can file application to the Kolkata patent office. So this is how one can identify the patent office where he has to file an application. So as I mentioned in the flow chart, which I have shown earlier, that after filing of a complete application, within 18 months, it will be published, and that will be open for the pre-grant opposition at any time before the pendency of the application. So, of course, after filing an application for the invention, the applicant also has to file a request for examination. So once you file request for examination, then only patent office will examine the application to ascertain its patentability. And so there is a form to file filing an examination, that is called Form 18. However, there is a possibility that a request for expedited examination can also be filed. So where Form 18A has to be used. So to file expedited examination request, there are certain criteria which a company or an applicant needs to fulfill. So he would have filed an application using Indian Patent Office as an international searching authority while filing PCT application. And also applicant needs to be a startup So these are the two criteria which needs to be fulfilled for filing request for expedited examination. So this is the examination procedure, how it happens at the patent office. So after filing for examination, examiner submits, so within 1 month, examiner takes the application up for the conducting examination and such. So examiner submits his report to the controller, who is supervising actually the examiners. So that controller within 1 month he issues first examination report, which is also called FER. So within 1 month he issues the FER, and within 6 months from the date of receipt of first examination report, an applicant needs to provide his response rebutting the objections raised in the first examination report. Okay, if within 6 months, if the applicant is not able to file the response, he can take additional 3 months of time. So by filing certain forms as well as the fees, so that he can get total 9 months of time for filing response to the first examination report. However, if the applicant could not file a response within these 6 months, or said 9 months with extension, then the application will be lapsed. So it cannot be revived by any means. So if after filing the response, if the controller is satisfied with the response provided by the applicant, then the applicant can get the grant of patent if the examiner satisfies with our response. However, if the examiner is not satisfied, then he can issue for a hearing notice. So in that hearing notice, I mean, again, we need to attend the hearing and we need to make post-hearing submissions. And once, if all the objections are satisfied, and then it will be granted. So when it comes to there are certain changes in the fee schedules introduced recently. So for individuals, startups, small entities, and large entities, there is a different category of fees. Even for recently, there is an amendment in the Indian Patent Act, wherein even academic institutes can get additional fee benefit. So these are the certain active or proactive steps taken up by the Indian Patent Office to encourage innovations and patent filing in India. Okay, so filing can be done through electronic transmission or by original document if needed within period of 15 days can be sent. Expedited issue of certified copies within a week's of time can be obtained. So power of attorney needs to be filed within 3 months from the filing date. There will be a fees advantage to the startups, as I mentioned earlier, for startups and individuals, as well as small scale entities. There is a fee benefit. So drawings or provisional specification can be adopted in complete specification by giving a reference thereof to the as filed PCT application. Abstract should be in a clearly defined manner. It should indicate the technical advancement. It should indicate the technical advancement of the invention over the existing knowledge. So this is about the patent examination procedure, which I have mentioned earlier. So these are all certain aspects which I have already covered while describing. So application is granted upon the compliance of all the requirement, as I mentioned. So letter of patent document will be issued by the patent office, and a publication made in the IPO journal. So publication of grant calls for post-grant opposition within 1 year from the date of publication. So Form 27 is something which applicant needs to file every year to the patent office to indicate about the working of the invention. So retroactive payment of annuity from the 3rd year onwards can be filed. The applicant needs to pay renewal fee every year within the due date. Renewal fee can be paid for 20 years term in one shot also, if the applicant desires to do so. Patent lapses if the renewal fee is not paid. So this is all about the patent filing applications and patent filing procedure in India. So thank you for your kind attention, and please feel free to ask any questions if you have.
Thank you very much, sir. Thank you, sir. Thank you for giving a brief about types of patents along with a flow process, how to go with the applying of the patent. Sir, I have one of the questionnaires, sir. May I know the difference between convention application and PCT applications? Sir? In the types of patents,
Okay, so
convention application
right.
and PCT.
Correct. Okay. So convention application is something where the applications are filed through Paris Convention route. So where applicant gets only 12 months time from the date of filing, from the priority date to file the complete application. Whereas in case of PCT application route, the applicant will get 30 to 31 months. For example, in India, it is 31 months time. So the applicant get extra time, but the invention, everything, the way of filing and all will be same. Only this route will give additional benefit of time so that, applicant take time and understand like where and all he can file his patent application. So that time he can get, accordingly he can make his, filing strategy. So that is the only advantage. Otherwise, invention remains same for the filing of a patent application.
Sir, from a participant, there is one more question here.
Okay.
What is the renewal fee?
So first of all, renewal fee, it depends on the nature of the applicant. One is like, as I mentioned, startup will be having a different criteria, and individual will be having different criteria. Large entities will be having different criteria. So it will be like for an year, it will be like it will be not huge amount. Like it will be like around 1,000 rupees, something like that. But it varies depending on the nature of the applicant.
There is one more participant, sir. Arshad Ahmad Khan has raised his hand. Sir, you can mute yourself. You can raise your question, sir. Arshad, sir. Or else make use of this question and answer poll so that we can have your clarity on your questionnaire. Or else make use of chat box, sir. There is one more. Dr. Bharat, sir, you can unmute yourself. Or else try to use chat box or question and answer poll.
Hello.
A few of the participants. Sir, please, Bharat, sir, you can ask your questionnaire.
Sir, can you briefly differentiate between this publishing and granting, sir?
Okay.
Publishing and granting.
Sure, definitely. So patent application will be published after filing. Within 18 months, it will be published, which means whatever the application that you have filed, as it is, it will be published. Okay, that is called patent application publication. Okay, after the grant of patent also, it will be once again published. So publication happens 2 times essentially. So one is after filing the application, within 18 months, it will be published. Once, see, while filing the application, there will be like huge number of claims. I mean, probably 10 claims will be there, 15 claims will be there, 20 claims will be there. But after the grant of patent, there will be variation in the number of claims because of the objections raised by the controller or Indian patent examiner. There can be variation in the number. So because of the certain objections, you may have to delete certain claims. or you may have to, modify the claims, the language of the claims. So all these modifications are essential before the grant of the application in view of the examination procedure that happens with the Indian Patent Office. So after the grant also, again, publication will happen. So actually that tells the protection rights, whatever that you are having for your claims. Okay.
So initially we will not have, sir, any protection.
So initially we will not have. So after filing a patent, what happens is you will be having the priority date. So from that priority date, your rights will be blocked, so that so as such you will not be having rights, but your rights will be blocked, which means essentially that even if somebody files same kind of invention after filing of your application, then that will not be getting weightage. Your application will be getting weightage because you have filed it first. Okay, so that is the kind of advantage. Of course, what you can do, suppose if you get to know that somebody is making utilization of your invention and commercially exploiting your invention, then you can send him a legal notice saying that, boss, see, I have applied for a patent, so stop working on that invention. Otherwise, once the patent is granted, I will take, I'll sue for whatever the infringement that you are doing. Like that, we can send a legal notice. So, but till the grant of patent, we can't take any legal action, even if someone is commercially exploiting your invention. But certainly, yeah, you can send such legal notices. But once the patent is granted, and then you can actually, take any legal action, because you have now rights for your claims, right? So that is where your actual legal protection right starts over your invention.
Okay, sir, right.
Hope I have addressed your query, Dr. Bharat.
Okay, sir. Thank you, sir.
Yeah.
Arshad, sir. Raise your question, sir. Thank you very much, sir, for your excellent presentation. And
Thank you, Dr.
understanding
Mani.
us how to go for the applying of the patent and the basic types of patents, and knowing about the flow process to undergo patents. Thank you very much, sir.
Thank you.
With the permission of principal sir and organizing secretaries, we would like to felicitate you, sir, through virtual felicitation. Kindly we request you to accept this virtual felicitation, sir, please.
Sure. Thank you. Thank you, Dr. Muniz.
Yeah, thank you, sir, for your kind support during our conference, sir.
Thank you. I'm happy to give such presentation to Santiram College of Pharmacy. So I think last year also I gave one presentation
Yes, sir. Yes, sir.
regarding the basics of patents, and this year we again worked on this piece. And so going forward, yeah, I'll be giving talks on patents. I'll try to enrich your faculty and college members on this aspect related to the patents.
Thank you, sir. Need your kind support, sir.
Thank you. Sure, definitely. Okay, sir. Thank you. Bye.
Thank you, sir. Thank you very much for accepting our invitation. Promptly
Thank you, Dr.
responding to our mails and the phone calls. In future also, we
Sure.
cooperation for
Sure, definitely.
sharing the same knowledge to the young people who are pursuing the analysis and different courses in our college.
Sure.
Thank you, sir.
Thank you. Okay, thank you.
I request all the delegates to again join the same link at 4:30 for valedictory function. Prizes for different categories in the same valedictory function. So I request everyone once again to join the same Google Zoom link at 4:30 sharp. Thank you, one and all.